Welcome to this professional development module on legal and ethical issues for healthcare professionals. In this video, we explore the responsibilities, rights, and risks at the intersection of medicine and the legal system. Why does this matter? Healthcare law is not optional reading. It shapes your daily practice, including how you chart, consent, and provide care. Evidence shows medical errors are a leading cause of mortality, making legal understanding crucial for every clinician. This video covers 6 key areas: foundations and governance, professional liability, corporate compliance, patient rights and advocacy, advanced directives, and practical steps for protecting yourself in the event of a legal claim. Law and ethics represent 2 systems operating at the bedside. The law serves as the floor, the rules of conduct enforced by the state. Ethics serves as the ceiling, the aspirational principles the profession expects of itself. Healthcare ethics are built on 4 core principles: autonomy, which respects patient choice; beneficence, acting for the patient's good; non-maleficence, the duty to do no harm; and justice, which requires fairness in resource distribution. When these principles collide, an ethical dilemma occurs. Managing these situations requires a disciplined approach. Name the conflict precisely, utilize a structured framework to evaluate the facts, and escalate to an ethics committee if necessary. A single incident can trigger 2 different courtrooms. Civil law focuses on compensation between individuals, while criminal law, involving the state, seeks to punish offenses against society. It is important to understand which branch applies in a given situation. Healthcare organizations are typically structured as corporations under state law. This creates a clear chain of authority, from shareholders and the board down to administrators and staff, ensuring accountability for corporate actions and decisions. Governance involves 2 types of authority: express authority, which is specifically granted by statute, and implied authority, which allows for the actions necessary to exercise those express powers effectively. Part 2 of this module focuses on professional liability, exploring the legal doctrines that govern the relationship between medical outcomes and legal action. A tort is a civil wrong against a person or property for which the law provides a remedy, such as monetary damages. The primary goals of tort law are to discourage wrongdoing and to provide indemnity to injured persons. Negligence is the most common medical tort, defined as a failure to exercise the reasonable care expected of a professional peer. Malpractice is specific to negligence by licensed professionals, where the standard of care is not met. The scale of medical error in the United States is significant, with hundreds of thousands of annual deaths attributable to such errors. These are often driven by systems issues rather than individual failings. To prove negligence, a claimant must establish 4 elements: duty, breach, causation, and damages. If any one of these elements is missing, a claim of negligence cannot be sustained. Liability requires harm. An unfortunate outcome does not automatically constitute negligence. Negligence itself generally takes one of 2 forms: commission, doing something you shouldn't have, or omission, failing to do something you should have. Let's review 6 common situations where nurses face claims of negligence, as frequently highlighted in risk management reviews. These include failures in following orders, responding to condition changes or communication protocols, as well as patient falls and equipment safety. The foundation of all professional liability is the, quote, duty to care. This is a legal obligation to provide care and perform duties in a manner that safeguards the patient's rights, meeting the standards expected of a trained professional. Legal liability can extend beyond the specific clinician involved. Doctrines like corporate liability, Respondeat superior, ostensible agency, and res ipsa loquitur are critical legal frameworks that can bring organizations into a liability dispute. Respondeat superior literally means let the master answer. It illustrates how an employer is held liable for an employee's negligence performed within the scope of work. This rule encourages institutions to build safer systems and ensures adequate compensation for victims. Beyond negligence, we must consider intentional torts. Unlike negligence, which is based on carelessness, these involve deliberate acts such as assault, battery, false imprisonment, defamation, privacy violations, or fraud. Malpractice insurance may not cover these incidents. When a legal claim is filed, not every case succeeds. Defenses exist that can defeat or reduce liability. The most powerful tool at your disposal to support these defenses is your own documentation, complete, contemporaneous, and accurate records. Now we turn our attention to the 3rd part of our module, corporate compliance. We will discuss billing integrity, the role of the compliance officer, and the vital programs that help institutions maintain legal standards. Compliance in healthcare means providing and billing for services in strict accordance with governing laws. This requires dedicated oversight from a chief compliance officer and a cross-functional committee to identify and prevent fraud or billing inaccuracies. Building a culture of compliance starts with effective education. Training must cover corporate ethics, fraud and abuse laws, billing processes, and ethical management, ensuring all staff understand their role in maintaining the organization's integrity. Part 4 of our series addresses patient rights and advocacy. We will cover the essentials of consent, confidentiality, and complaint handling, recognizing that patient dissatisfaction is a significant risk management issue. Patients are central to healthcare, and their satisfaction is directly linked to legal risk. Research shows that litigation is often driven by communication failures rather than pure outcomes. Effective patient advocacy minimizes these risks. A patient's Bill of Rights includes fundamental protections: the right to respectful care, understandable information, active participation in treatment plans, non-discrimination, privacy of records, and the ability to voice concerns without fear of retaliation. Informed consent is the voluntary agreement of a capable patient to a procedure. It relies on 3 pillars: the disclosure of all pertinent information, the patient's capacity to decide, and the absence of any coercion. Consent can be express, such as a signature on a form, or implied, such as a patient extending their arm for a blood draw. Understanding the difference is vital, as invasive procedures typically require formal, written express consent. Finally, we encounter complex consent scenarios involving minors, adults without decision-making capacity, or informed refusals. Each requires specific knowledge of legal rules and thorough, meticulous documentation to protect both the patient and the care provider. Confidentiality is often called the oldest promise in medicine. It is the obligation to keep what is learned during a patient's care inaccessible to anyone outside the treatment team, unless the patient consents or the law mandates disclosure. This duty rests on 2 foundations. Ethically, it is rooted in trust and autonomy. Patients disclose sensitive information only when they feel safe. Legally, statutes like HIPAA make privacy enforceable, with real-world penalties for breaches. The duty is strong but not absolute. Exceptions are narrow: patient authorization, treatment team requirements, mandatory reporting like abuse, a duty to warn, court orders, and public health emergencies. Always limit disclosure to the minimum necessary. When patients complain, it is rarely just about the diagnosis. They are often reflecting on the journey. Was the team attentive? Did they wait too long? Was their privacy respected? Analyzing these complaints is essential for performance improvement. Patient satisfaction metrics are more than just quality data. They are a window into your risk profile. Satisfied patients are loyal. Dissatisfied ones are the most likely to file claims. Addressing complaints early often prevents lawsuits. We now move to advanced directives. When a patient can no longer speak for themselves due to lost capacity, their previously stated wishes must carry the weight of their decisions. An advance directive is a document created by a person of sound mind that outlines their medical wishes. It ensures that a patient's right to accept or refuse treatment continues even after they lose decision-making capacity. There are 3 primary legal instruments. A living will specifies treatment preferences. A physician's directive provides guidance on withholding life-sustaining care. A durable power of attorney appoints a surrogate agent to make decisions on the patient's behalf. Effective implementation of these rights happens at the bedside. The law requires institutions to inform adults about these options at admission. This interaction must be documented clearly in the medical record and reviewed periodically. When capacity is lost, the directive is retrieved and verified. The agent is contacted, and the patient's plan is executed. This process honors the patient's voice, even in their most vulnerable moments. The final part of this module focuses on protecting yourself. The best defense is built long before a claim arises, through disciplined charting, clear policy adherence, and professional communication. Your chart is your witness. Because memories fade and witnesses scatter, the medical record is the only voice that remains. Document facts, not opinions, and record refusals, education, and follow-ups meticulously. Never alter or backdate an entry. Understand your malpractice insurance. Whether you have an occurrence policy or a claims-made policy determines your coverage. If a claim ever arrives, notify your insurer immediately, preserve the record, and speak only through legal counsel. In conclusion, remember these 6 points. Law is the floor, ethics is the ceiling. Negligence requires 4 elements. Liability often follows the institution. Consent is required for every touch. Complaints are the path to lawsuits. And your chart is your ultimate defense.